Court will call the State of Wisconsin versus Ian Olson, 23 CF 1647. Could I have appearances, please?
State appears by Chelsea Thompson.
Justin Singleton appears on behalf of Mr. Olson, who also appears in person and out of custody. Good morning, everyone.
We are here for jury status. Is this matter still in litigation?
Yes, Your Honor.
Okay, so the court is going to conclude the issue regarding the use of material that was subject to the warrant that I included lack probable cause due to this lack of connectivity between the residents identified in the warrant request and the defendant. The court left open the question as to whether or not the good faith exception would apply. I note that the commissioner for the federal district in reviewing that concluded that the good faith exception did not apply because in their observation the warrant was so lacking in probable cause. The commissioner in the federal case, just by observation, went further than I did in terms of their umbrage related to the probable cause standard. I simply reviewed it in terms of the lack of identified connectivity. There was an address provided but no description as to why it was relevant or connected to the defendant. In this case, other than a reference to a certain crime type that was being reviewed, the court believes that caused it to lack probable cause. The commissioner went forward with other observations which I am not in agreement with, mainly that there was some disconnection between the crime type that was being described and the reasons for in support of probable cause. The court believes that, as I said on our last hearing, that events can have more than one reason, and certainly the crime of stalking has a broad panoply of potential fact patterns that can occur and involve speech directed to an individual or property, which may be considered as an exercise of conduct directed to an individual, potentially, depending upon what the fact finder finds. So the court limits its conclusion as to the lack of probable cause to the issues as I've just described it solely. I then move forward and review the good faith exception, and I have drafted a conclusion which I'm going to sign. That conclusion sets forth the standard for good faith in Wisconsin, citing the Eason case, 245 Wisconsin 2nd 206. In that case, that involved the use of a no-knock warrant that was deficient for reasons unrelated to this case, but regardless, which caused the reviewing courts to conclude that there was a lack of probable cause. The Supreme Court of this state in 2001 in the Eason case detailed what would be necessary for purposes of the application of the good faith exception. Good faith exception in Wisconsin is applicable and allows evidence to still be used by the state if the state can demonstrate objectively that the police reasonably relied upon the warrant issued by an independent magistrate and that the process used in obtaining the warrant included a significant investigation and a review by either a police officer trained and knowledgeable in the requirements of probable cause, reasonable suspicion, or a knowledgeable government attorney. The court believes that all of those factors are present in this case after I, as the Supreme Court did in Eason, reviewed the warrant affidavit, the affidavit in support of the warrant, and the detail that was provided in that warrant, which was significant and which had ties directed to the defendant, including information as to the defendant being discovered at some earlier juncture on the recruiting base. So the court believes in reviewing that warrant, and all paragraphs of that warrant, that there does demonstrate a significant investigation leading up to the conclusion and application for the warrant. The court does believe that there was an independent magistrate and a separately elected circuit court judge who reviewed the material, and who likely, in my observation, concluded that the address that was being sought was that of the defendant's residence, although that was facially defective, which caused this court's conclusion regarding the lack of probable cause. The effort by an independent magistrate was clear from this court's observation, and the court also observes that there was the review not just by a signature of the law enforcement officer, but approval by a deputy district attorney in Waukesha County, which, in my experience, take judicial notice of the fact she has been practicing, because she's been practicing for as long as I've been here. So she's been an assistant DA or deputy DA for over 15 years. So I believe all of that supports the conclusion that the good faith exception should apply. Therefore, the court will deny the defendant's motion to suppress evidence of the search conducted by the Brookfield Police Department on October 16, 2023. And subject, of course, to the rules of evidence, that information is available for use during the course of the trial. Now, I know that the defense has filed a request for special instruction, which I'm not going to address today. I just want to observe that it's been filed, and that will be a point of some discussion in the future as we get to the point of dealing with instruction. But I appreciate at least the heads up as to the request, so we can be considering and thinking about that. I believe that the defense filed a listing of requested jury instructions, but not actual instructions. Is that correct?
Correct, Your Honor.
One of which struck me as confusing, which is the self-defense request. Is that a standard request that you include in all of your instructions?
Yeah, I think, and I've got these, I think usually it says where appropriate.
Well, there were ones that said if applicable. That one didn't say that, but it just struck me as not present here in this case, unless I'm missing something.
Your Honor, at this point, I'm not aware of it being present. I try to cover that because obviously my client could say something on the stand.
You were just covering your base.
Yes.
Okay, and then did the state file a listing?
I did not, Your Honor. I can do that today. That was an oversight on my part, mainly thinking
I was trying to remember whether or not the state had filed one earlier, because this has been set for trial multiple times. My clerk's shaking her head.
No, I
she
don't
doesn't believe the
that.
state had previously filed.
I do not have any out of the ordinary ones, but I can still file a standard list, and I can also prepare a proposed substantive instruction for the charges and provide a copy to defense.
Now, I'm going to recommend it because I've had stalking, as I've described before. I've had stalking trials before, and not with Ms. Thompson. And I can recall, because what I do with a jury when they come in is I read them the charging language, and the charging language was so looped because of all of the different, in the stalking count, that the assistant district attorney at that time started to get not upset, but wanted to make changes, and there was no real controversy about the changes because it took away certain potential exposure, I think, for the defendant in that case. But it just became very disruptive because the jury heard one rendition, which was not very So I'm gonna recommend that you take a look at that, make sure you're, if there's any issues, that we deal with that, in advance, and that you have a conversation with Mr. Singleton if there's, anything that you're gonna seek, so it's not just on the morning of trial that we're all trying to react to it.
Your Honor,
Yeah,
as to that, there is the section that obviously, in the jury standard instruction, it says, you know, add these various ones where evidence is supported. I think it would help, I think, a colleague, counted there's maybe 108 clauses if you put them all together. If the state could limit, you know, which ones that they're potentially going to request, out of that section, which they think the evidence
well,
might.
that's in the instruction, and I agree, it's gonna be conformed to whatever the evidence introduced is, but I'm talking about the charging language, and that's where the hang-up was before. So, and frankly, I haven't gone back to the information to kind of spend time to do that, but my clerk is directed, by me simply to lift and, paste it into my initial comments to the jury pool so that they understand why we're all here, and that's where the issue, arose. So I'm just trying to identify that as a potential for the state and the defense's review, so we are not confusing as to exactly why we're here. As to the issue, though, Ms. Thompson, you agree that you're gonna boil this down to, certain buckets, right?
Yes, absolutely.
And my guess is you're gonna do that before you start your case, right? You're gonna identify what your case is.
Oh, yes.
Right?
Yes.
And you're gonna talk with, Mr. Singleton, so we're all on the same page on, as to why we're here.
Agreed, and if we were, I haven't taken a deep dive into the motion for special jury instruction, but anything that defense wants to be able to say is lawful, such as the assembling peaceably or picketing, that's not in the course of conduct that I intend to present to the jury.
So that's one of the reasons why I'm holding on that, because as I reviewed that, I thought, I'm not really sure what the evidence is gonna show. And if there is, and there is a statement in the statute that says, and I'm paraphrasing, but, otherwise legitimate activities are not prohibited by the stalking statute. That was an effort by the legislature to kind of keep it in a constitutional, boundary, I believe. And I believe that the defense's concern is that there were certain activities that were described in the complaint. Make sure I'm right about my memory. And I'm not relying on the affidavit in support of the search warrant, but at some point there was description of the defendant having, stood in silent protest or holding up signs, and so more of a traditional expression of disagreement or dissatisfaction in terms of exercising freedom of speech. I have no idea if that is at all part of this case or will be part of the evidence in this case. If it is, then I think it becomes more likely that there has to be boundaries, and perhaps, I don't know this, maybe the state, maybe the defense is gonna want certain information and may argue why it's relevant here, and I don't know whether it is or it isn't until I hear the offer and whether there's objection to it, but that's all gonna wait at this point. And that's why I'm waiting on the issue of the special instruction. The defense did include its theory of defense, so at least they've set forth what their belief is, and we'll see where we head from there. I'm going to talk about the jury pool for a minute. I've expressed some concern over making sure that we have, I guess, a jury process that is efficient and moves forward, but also allows for there to be a vetting of experiences so that you all can exercise jury strikes from your perspective in the manner that you wish to. The court is going to bring a jury pool in. I have alternates because of length of trials of two. I think we should have two. So I'm going to include two, which will alter the number of jury strikes, and Molly's going to do the math on that because I always screw up when I have to
I have not.
So typically I do an initial commentary and questioning of the jurors, sometimes substantively, not just on sort of the procedures of being a jury stuff. And I'm intending at this juncture to broaden it to subject matters that I think should be part of the discourse in terms of understanding jury experiences and what their position is. So some of it will involve the Constitution, whether or not there's acceptance of certain precepts in the Constitution relative to the right to trial, the right to remain silent, the right and other areas that I'm considering asking will involve questions regarding the government. I have in the past asked about the district attorney's office, but I'm intending or thinking about asking a broader question here regarding people's, whether anyone has any strongly held views regarding and you can tell I'm still forming this, but the strongly held views regarding the government, whether it's state, local, or national, in some fashion, because there will be testimony about the defendant, and part of the information will be the defendant's action or alleged action directed toward the governmental agency. And so to sort of comb out whether or not you're going to get somebody who's going to come in and just launch their hand up because they feel that they need to express that view. And I've had that in other trials where people have come in, and when you touch that button, whatever the button is, then they respond to it and they want to talk about it. Sometimes it's a victim issue when we have a drunk driving trial and they have someone who's either seriously hurt or killed in their family, and that is one that launches them, and they want to talk about that. One of the risks of that is that you infect the jury pool. So I tend to try to limit the information so we can get flavor. My purpose in doing that is typically not to shortcut the attorneys from doing their job in terms of having the right to reach inquiry, but I don't want to I don't want to turn this into a proposition of probing that's going to go on so that we are inefficient in terms of our process of concluding that process of selecting a jury. My juries are typically selected well before noon. Many times my juries have opening statements before noon. And I've had both what I'll consider not as complex and more complex trials. I know other courts tend to ask all questions, and I have resisted that because I do think the art of being a trial lawyer is the art of developing the experience in doing that. So I intend on allowing counsel the ability to ask some questions, but I'm going to caution you that I'm not going to allow it to be sort of a free range in terms of subject matters that are going to get off the road, and if that happens, I'm going to stop you. So that's a warning. The other thing I wanted to discuss is the number of witnesses. So the state is a lengthy list, I think 17.
I do, but I've already started canceling people as I've pared it down.
Okay, so that cost me to lose sleep already.
Me too.
Because I was concerned about the length of time we had for trial, 4 days, and I do think this can be well tried within that 4-day period. I just want to make sure I reinforce as I have in other trials that I expect that the witnesses will be handled in an efficient fashion, limiting redundancy, and no large gaps in terms of the ability of witnesses to be present so that we can respect the jurors that are taking time out of their work, their employment, and their families to be here. And one of the reasons why this is not a pro forma hearing, this jury status, is exactly that. I always ask, is this matter still in litigation? Because frankly, I want you to hear that I expect it's going to go to trial. Now, that doesn't mean you have to go to trial, but it's my expectation, because once we call in, I don't know how many we have, 30 or 40 people, and cause them to have to take off their day. Sometimes they're not compensated. Many times they're not compensated, and they receive simply a stipend by the county, which is frankly not even enough to buy dinner. It is an interruption clearly in terms of their day and their rights as citizens, and that's their obligation, which I'll explain to them. But I want you to understand that I expect if there's any potential closure, that today is the day that that's going to happen. And if it isn't, then I'll bring you back on Monday and hear from you then, so we can try to avoid that disruption of normal people in terms of their lives. We begin at 8:30 with the jury pool, but I'd like everybody here at 8:15 so we can deal with any preliminary or initial matters in terms of motions to eliminate, if there are any specific issues that you feel I need to address. You did file some motions to eliminate, counsel?
Yes, Your Honor.
And you want me to hear about any of those here today?
Your Honor, I think the only one that perhaps might, if I don't know what the state is intending to admit in terms of proving the marijuana. So if there's expert evidence or potentially daubered evidence which would be impacted by that, I think that might require more time than we would have on Tuesday morning.
We don't have a lab report to answer the question. So no, there is no expert report communication over.
So what's the state offer as to how they're going to demonstrate that, or are they pursuing that claim?
I'm working on it.
So I'll look for a put up or shut up moment morning of trial.
Correct. I have proceeded to trial without a lab report before.
Well, that's why I'm phrasing it as I am.
Thank you.
But there are occasions where it simply isn't worth the squeeze because you don't have the ability, and if you recognize that, we'll move on.
Yes.
I'll hear from you on Tuesday morning about that. Mr. Singleton, was there anything else?
I think that was the only specific motion that we cannot, that wouldn't be, I understand the state just got them yesterday. They may need to look at them a little bit more. I don't think there's anything else that's going to take a substantial time to address. I'm pretty sure everything else in there is the standard motion limine that I filed over and over.
And that's why I phrased it the way I did, because many times lawyers will file, and then they'll want to identify certain ones that they think are important. So I'm not going to go through an academic exercise because we don't have the time. I don't have the energy, frankly, to do that in every case. From the state, you had filed the witness list. I don't recall whether you had filed any motion.
I did not file any motions to eliminate. Any that I would have filed would be covered by the rules of evidence. But as I was sitting here, I was thinking that I should have filed one because I will be asking for the court to allow Officer Brandon Pitts to be my court officer. I think in this case...
He's from the city of Brookfield?
Yes, he is. He's the investigating officer. He has extensive knowledge on the history of Mr. Olson as it relates to the other acts evidence, the criminal damage reports leading up to and including the stalking investigation. There is a statute.
Just a minute. Any objection?
Your Honor, partial objection. My general request in that regard is that this court has obviously substantial discretion in determining the order in which evidence is admitted, and when the state seeks to have an individual whose testimony is intrinsic to the resolution of the matter. I believe that it's appropriate to have that individual testify first, or at least early on. It balances the statutory authority by the government to have such a person there to help manage their witnesses, while also recognizing that the court generally has witnesses who are, keeps the witnesses from hearing each other's testimony. And so to the extent that that's a recognized value to the jury, to keep the witness testimony segregated from each witness, having that, if the state wishes to have that officer testify, having them testify first prevents that contamination without undermining or depriving the state of any evidence.
Let's deal with this on Tuesday morning, but I'll indicate that generally I certainly allow a court officer to be present, and the state's selection of court officer is typically the effort that they engage in order to have the person they feel is going to be the most assistive in terms of their burden of proof. So I don't generally step on that. I'll let Ms. Thompson mull in response to this request regarding order, given the fact that I believe she's still trying to set her deck chairs in terms of the way this will be presented, and perhaps this won't be an issue on Tuesday morning. Anything else, Mr. Singleton?
Yes, Your Honor. I heard the court in discussion with the deputy clerk that there may be 30 or 40 in this jury pool. I honestly have never had a case. I've had certain types of charges, certainly sexual assaults, domestic violence, where we end up going through a lot of jurors who raise their hand and say they just don't feel that they could enter a fair verdict or review the evidence appropriately. I don't know if I've ever been in the situation where the armed forces are so intricately intertwined here. I am concerned that...
I'm going to ask a general question.
Yes, sir.
About military.
Yes, that's what I'm wondering, is that
regarding military,
perhaps that their membership in the military may impact their decision in this case, and also may also cause us to lose a bunch of jurors. Again, I don't know.
Well, I'm not sure that that's disqualifying.
No,
I
but...
certainly think it's something I can ask. And let me just generally say, and I didn't say this, so I should have, which is that I always accept requests by either side to inquire into certain areas that they feel that they want the court to inquire on because they're concerned that the area may be sensitive or cause a reaction directed to them by another potential juror in the jury pool that may be selected. And typically, the example is sexual assault cases, where people have obviously had own personal experiences or have very strong opinion, and sometimes having the court ask those questions gets the information out without causing the counsel to be sort of in the crosshairs. So I will consider that request and any from the state as well. We can talk about that on Tuesday morning.
Thank you.
Now, Ms. Thompson, anything else from you?
No, I will put in writing my request for the court officer, and I will file jury instructions and propose substantive instructions and work on condensing the charging language of the stalking count.
Okay. All right. Again, 8:15 on Tuesday morning.
Your Honor, sorry, one more thing. I thought the statement moved to
Oh, you had forecasted a certain capacity you're going to take out on.
I'm not in a position to do that yet, but I will be Tuesday morning. I think it is highly unlikely that I will be proceeding on the other two stalking
Well,
counts.
Mr. Singleton has a right to be able to prepare.
Okay, I will get an answer by the end of the day today.
So I would expect then that you would file with me a statement as to which counts the state is not pursuing, and then Mr. Singleton, when you receive that, it will be filed in CCAT. I would ask that you file a written response whether there's an objection or not objection. My guess is you'll have no objection because obviously it limits your client's exposure. But I just want that of record, because if I get that, then I'm just simply going to direct the court clerk to
Thank you, Ed.
Okay, that's it for today.
And this does not have to be on the record, but would you allow me to pre-mark exhibits? Your trial order says prepare lists for the court to follow along with, but would it be okay if I pre-mark exhibits?
No, I don't have any problem with pre-mark.
Is that okay? Okay,
Yeah.
some judges do have a problem with it, others are okay with it, so I just couldn't remember from our last trial.
No, I think we prefer that they be pre-marked.
Okay.
So that we're not doing it at the clerk station.
Okay.
That's kind of the old school, just to do it at the clerk station. But you're all officers of the court, so I expect them to be accurate. And they'll be checked by Molly, of course.
Okay.
The other part of exhibits is technology. And for both counsel, make sure that you are, if you have things that you're gonna use that require, my clerk is not your computer person, I am not your, and you don't want me to be your computer person. So make sure that you try out whatever it is. We certainly will make the courtroom available prior to Tuesday, so that you can do that and make sure things function and audio works and all of that stuff, so we're not spending a lot of time trying to figure it out in front of the jury. It makes us all look bad.
On that, just briefly, so I took trial ad before electronic filing and all the screens everywhere, and so generally when I prepare for trial, I end up with multiple copies of every paper copy of every exhibit, because that's where we started out. But now we're able to easily present documents on screens in a way that jurors can review them. Is this court okay with otherwise printable documents being displayed electronically
Yes.
rather than printing them out and
Yes, as
killing
long
the
as you
trees?
follow the correct procedure, which is to have it identified by a witness, so that ask the clerk to have the screen turned on in the witness box only, and then demonstrate that whatever the document is to the witness, identify whatever the exhibit number is for the document, have the witness identify the document, assuming that there is authentication, move for admission, whether there's an objection or not, I'll deal with. And then once it's admitted, ask for publication, whether there's objection to that. And typically, if it's been admitted, it will be published, unless it is so offensive that I'm likely not to publish it in terms of the typical manner with these large screens in the courtroom. And that's not this case, so I'm not going to go down that road. But no, I don't have an issue with use of documents in the witness box. I find it to be more efficient.
Thank you, Your Honor.
Okay.
You asking about using like the projector for paper documents?
Yes, like,
Okay.
so looking at your computer, putting it up on the screen rather than handing everyone a paper copy.
He's talking about using it off his
Okay,
computer.
I wasn't sure if you were saying paper copy. I have the Elmo that projects it, so I just need.
You're not talking about physically using a
No.
piece of equipment, right?
Correct.
Okay.
One little complication here. Are you incapable of having a poker face? It's not a performance or a theatrical, but there should be no circumstance in the entire trial and really ever in a motion hearing where you are guffawing and laughing at things, okay? Unless it's an absolute joke that everyone else is laughing about. It's a serious circumstance, and when you're up there laughing, you make it look like you're not taking any of it seriously. I don't know if you're ever going to be sentenced on anything, but that's going to be an issue down the way if you are. Also, the jury doesn't like when they're there off of work and they took their time off and they're working really hard to make smart decisions and weigh everything. If you aren't taking it seriously, they're not going to take it seriously. So, look, you don't need to give anything away. Take it seriously, but you know, laughing inappropriately is not gonna help you at any point with anyone in there. And so, and I don't want, did you see me react? We're gonna, no, we've got more time to make that decision. We'll talk about it again. We gained more information today. But laughing about what we haven't done and tipping their hand, I'm not tipping my hand. You know, if she wants to go ahead and spend her time waiting and not expecting to go ahead and call these witnesses, and she hasn't contacted them, and then we go ahead and flip it on her, better that she doesn't know, right? If that's what we choose to do. So, I mean, your emotional expression, I don't know if it was performative or genuine. If it was genuine, you need to rein it in. If it was performative, you need to rein it in even further, because we don't need to perform about how funny we think that things are in the court. Nothing funny is happening in that court in anybody else's mind but yours, okay? That's my knuckle rapping, okay?
I understand. I have a couple quick questions though.
Yeah.
What is a case, officer?
It's not, you said it's not necessary. The question becomes, despite your loyalty in your 22 years in the U.S. Navy, are you able to, do you believe that you're able to fairly and lawfully consider the evidence in a manner that gives full faith and credit to the defendant and his rights? Some people will say no. Some people will say, actually, I don't really think so. I love the Navy, and I feel like it would impact my decision, and that person's going to be excused for cause.
All right.
All right?
All right.
The person who says, oh, no, I can be impartial, that person's going to get through, and then we're going to get peremptory challenges. He says he didn't know the number. I think it's 4 on a 4-day trial with 2 alternates. But again, I don't know the math either. And as he said, I don't do the math. She does the math. It is a formula. Number of days of trial, number of alternates, and then some somehow comes into. But peremptory challenges are people that I can excuse for without giving any reason, and I think I can excuse them for any reason. The state cannot act with they cannot seek a racially pure verdict jury, so they cannot excuse all of black jurors without good cause. But otherwise, peremptory challenges are pretty much I can do whatever I want. Okay.
All right.
And I will probably bump anybody who's previously served in the U.S. Navy. That's probably on the top of my list of people I want out, because I don't want them going into the jury room telling stories about their friends and how I was a Navy recruiter and my buddy was a Navy. They have to deal with all these, and bringing that emotional element in there.
Yep.
Speaking from their experiences, but there are other things that could cause me to go ahead and have more reason to jump a juror. There isn't on it. There are some people who probably would say that they win their case on voir dire. I don't think we're going to win the case on voir dire in Waukesha County. We could potentially lose it, but we have to recognize that we've got a bunch of. This is the worst time this trial could have happened in the spate of Charlie Kirk. Conservatives don't know if they're pro cancel culture or pro First Amendment. They just cannot decide. And I don't know if I have a strategy, because there isn't. It's not like this is what conservatives think. Conservatives think 4 separate things simultaneously that are all in contradiction with each other.
Yep.
And I don't know how to even voir dire around that, because they all suck. The answer. They don't understand why. Well, why did what's his face? He just got canceled and then reinstated.
Jimmy Fallon?
Jimmy Fallon. Why did he get, why do you have a problem with that?